defendant destroyed ancient monuments in Timbuktu. I mean, how more iconic a case in some ways can you get from that? And the court is slowly working out questions about reparations, and in particular one character, Mr. Bemba from the Central African Republic, looks as though he might have money. About $1 million actually. $1 million doesn't go very far with the victims of his depredations, and unfortunately, and this is a big crunch problem with this, if you prosecute this kind of case and on the face of it they don't have any money, you've got to give them legal aid, and there's been enormous investment in legal aid in his defence, not unreasonably in my view, but it may well be that the court itself will get the money back for the legal aid output rather than for the victims. So we'll see how all that works out. One of the things that let me just leave you with this thought, and I think it's important in some ways for NGOs to think about. In some ways, it was surprising to find several hundred NGOs generating this stuff. And I think this is a negotiation which would never have been concluded had it not been for people like Amnesty International, both at the big level and in the various states. If it hadn't been for that influence, it probably wouldn't have happened. In some ways, if you think about it, human rights organisations are usually on the side of saying, we don't want people prosecuted, let them go, and so forth. But here are awful people who do want prosecuted. On the other hand, it was very important to them that protections for the defence, like those in the International Covenant on Civil and Political Rights, find their way into the treaties, and very significant defence rights and so on. These are criminal proceedings. And at the end of the day, you've got to prove it, don't you? You've got to front up and you've got to show that the defendant did what you alleged that he or she did. And at the end of the day, if you can't do that beyond a reasonable doubt, you lose. And there have been a few unsuccessful cases so far, which is good, I think, although it's unfortunate the prosecution wasted its resources, it turned out, but they gave it a good faith run for the money and it didn't work, and that's how it should be. But bear in mind, if you make a decision to call something criminal, you got to prove it at the end of the day. Look, I've talked enough. Let's.
Can I? Yeah. One thing that's really always puzzled me is why can you only prosecute countries that are signatories? Because that seems to me the weak point.
Well, of course it's a weak point, and we lost that negotiation. As I say, I thought we were on good grounds, and the Germans agreed with us that these are crimes of universal jurisdiction. And the theory, if I understand it, at Nuremberg was that just exactly that. These are crimes that anybody could prosecute, and as it turned out, the four prosecuted on behalf of all the rest of the states. But they weren't prepared to accept that proposition in this context. They said, no. These really aren't crimes of universal jurisdiction. We might have said that once, but we don't think that anymore, and we're not going to agree to that at this point. Yeah, you know, a consensus negotiation is a very interesting animal, actually. I mean, take my nuclear weapons. I'm sure that if we had forced this to a vote, we had about 70% of the votes in the House for including nuclear weapons in the treaty. On the other hand, we didn't have the 5 permanent members of the Security Council and the allies of most of them, namely NATO. We didn't have Canada. We didn't have Germany on this issue, and so on. And in theory, with a 2/3 vote, we could have got it, but we wouldn't have a treaty at the end of the day, because these characters would bail on us. And there are some really hard judgment calls you make at those times. And the jurisdictional one was another one of them that, we just couldn't get a consensus on. And back to the drawing board, you take what you can get. Aggression is even worse, actually, because we're at the position, ultimately, where states that don't agree to the amendment, as opposed to the treaty itself, aren't bound by Now, it's not all bad, because if you think about this, assuming, let's say, let's think of a non-party, an Indian, let's say, a citizen of the Republic of India commits a crime within the statute in New Zealand, there's jurisdiction in the International Criminal Court because the territorial state, New Zealand is a party to the treaty. Okay. So because of the territorial stuff, if they do it there, we got them. We weren't able to pull that off in respect of aggression, but it's true in the case of genocide, war crimes, crimes against humanity.
But what about what's happening in Syria?
Yes.
With armies coming from Turkey and elsewhere?
Yes.
Does this fit?
Only to the extent that the parties engaged in this enterprise are party to the treaty. Now, Syria's not, and Turkey's not, but let's assume that British troops commit something, or alleged to have committed something, then you've got the nationality theory. This is, of course, an interesting question in relation to Afghanistan, which is a live one, because the prosecutor is investigating the situation in Afghanistan, where clearly the Taliban has committed some crimes, but it's probably the case that the government of Afghanistan has. Afghanistan's party to the treaty. And it's probably the case that the United States has committed some war crimes. Now, of course, the United States has been crying foul and says there's no jurisdiction in these circumstances, but response to that is, hey, you understood territorial jurisdiction, and you understand the proposition that if a Turk commits a crime in the United States, you prosecute him in the United States. It doesn't matter that they're Turkish, they do it here, there's jurisdiction, and so on. So I think the question is more live because of the parties involved in Afghanistan and Syria, but potentially there are some possibilities there. Now, there's one other thing that I should perhaps have mentioned in this context, and that is the Security Council has power to refer cases to the court. And if they do, then there is universal jurisdiction. They can get anybody. And they've done 2 referrals so far, the Security Council has, one in respect of Libya and one in respect of Sudan and the situation in Darfur. Now, in neither case has the court been successful in getting its hands on the people they'd like to prosecute, and the Security Council, frankly, has been at best unhelpful in terms of assisting in that endeavour. But you can, if you can get nobody to exercise the veto, get them out of the Security Council. But it's not an enormously promising avenue, it would seem, so far.
Where does this court sit?
Sorry?
Where does this court sit?
In The Hague. Yeah.
And is that the court that tried and convicted the war criminals from Bosnia and Serbia?
No. What happened was in 1993, 1994, the Security Council created 2 ad hoc tribunals, one to do former Yugoslavia and one to do Rwanda. And they actually did it at a time when, the idea of a permanent court had sort of been, well, it's been on the agenda on and off since the 1800s, but more particularly in the light of Nuremberg and Tokyo trials, was discussed for a few years, then got hung up with the Cold War, was back on the agenda in the late 80s. And there's a sort of a funny cause-effect thing goes on there, because the Security Council says, all right, well, we'll do this and this, and people say, well, wait a minute, why didn't you do one for East Timor? Why didn't you do, pick your favourite awful place, why didn't you have one for there? The Security Council doesn't have a good answer to that. So the argument then becomes one for a court that is open to everybody, universal, even-handed, and so forth. Actually, I never quite managed to articulate this very well, but in some ways, that part of the negotiation was a rerun of the fight in 1945 about the veto in the United Nations, because this is a court that middle and medium-sized powers were really keen on. If you're a small Pacific Island state with 100, 200,000 people, you don't have an army, you don't arm your police, all you've got's the rule of law. and this is really important to you, and you don't really want the Security Council just doing it when it feels like it. You want to be able to go to this. And I think it was, in many ways, it's a rerun, but a successful rerun in many ways of the argument about the veto in 1945.
Other questions? Yeah.
Sorry.
Oh, yeah. Thank you, Doctor, and thank you for your briefing. I'm the survivor of genocide from Darfur, as you mentioned. Darfur.
Okay. Yeah.
So I just want to know exactly. So the UN Security Council member referred the situation of Darfur to UN Security. I mean
to the ICC.
To ICC.
Yeah.
And so for last almost 9 years, 10 years, al-Bashir, who is a criminal who committed crimes of genocide, he's still free.
Yes.
And the two countries who always use a veto is Russia and China inside the UN Security Council. So do you think the same situation like using veto and still the victims waiting for a justice? So,
well, I agree that that's a problem, but Darfur is even worse than that, and Bashir is an even worse problem than that, in that he's been able to travel to a number of countries that are parties to the statute. South Africa, for example, has, I won't say welcomed him, but at least allowed him to get out of the country again when the courts tried to prevent him from leaving. It's clear to my mind that a number of states are in violation of their obligations under the Rome Treaty. All of them that have let him in and out are in violation of their obligations under the United Nations Charter because of the Security Council involvement. It's blatant and disgusting, and there's no early resolution in sight. The prosecutor goes down to the Security Council every year and says, "Help me. You sent me this case, and you've left me dangling in the wind." I mean, she puts it as bluntly as that, and there's a deafening silence that responds to it. It's a scandal. I don't mean this means we should give up, but
there is a way everybody could push.
I'm just hoping that Bashir is stupid enough to go to some decent country where they arrest him. Like to think that Canada or New Zealand would have the guts to actually do it, but I don't guarantee that that's right. You have this romantic view of the good guys, don't you?
So bad.
No, it's a terribly regrettable situation.
Has the United States ever been a defendant?
No. Well, as I say, it's pretty clear that the investigation into Afghanistan will probably turn up some crimes by American forces, and then there's going to be a pretty ugly confrontation. The United States has already been saying, look, we're not a party to the treaty, we don't intend to become a party to the treaty, and so on. The United States look, I've lived more of my life in the United States than anywhere else, it's a strange country, isn't it? Because in some ways, it does wonderful things, and in other times it does some of the grossest, most unpleasant things imaginable. And it became apparent to me about 1997, I guess, at a piece of the negotiation in New York. The light finally came in my brain. The United States was a vast supporter of the International Criminal Court at that point. We want this. But then you realized what they wanted was a court that you had to go through the Security Council to get to. And of course, they just put up their niet sign at that point. But they can apply it to everybody, but not us, because we're protected by the veto. And of course, again, that's the problem with the 1945 negotiation out in San Francisco. The Permanent Five say, hey, you don't agree to the veto, we're taking our ball and we're going home. So if you're a little guy, you take a deep breath and you say, well, okay, we're going to have to live with that. And we have had to live with that. But we did manage to get around that with the ICC, so that the Security Council doesn't have an absolute veto. They have what amounts to a stoplight power. They can agree to ask the court to postpone something for a year. But that is vetoable. It flips the veto on its head so that it works the other way. And of course, ultimately, I wish I'd been there. On the very last day that this was available for signature, you can sign and then you ratify. If you don't sign, you have to accede. It's a slightly different document, but no big deal. On the very last day it was open for signature in New York, the 31st of December, which was a Sunday, New Year's Eve. Clinton instructed his ambassador for war crimes to go down and sign it. So they call up the UN and they open the treaty office, and lo and behold, the Israelis and the Iranians show up too, and the three of them have a signing party. I'd love to have been there and see what they drank and what they said to one another, and whether they toasted the court and so on. But subsequently, both Israel and the United States have said, well, we didn't really mean our signature, we're not going to proceed with becoming a party to it. It's a shame.
Have many countries pulled out?
Well, that's an interesting problem. Year before last, 3 countries which were getting some grief. South Africa over the Bashir problem, Gambia, which was being investigated, and Burundi announced they were pulling out. Gambia had a change of government relatively peacefully and immediately withdrew its withdrawal. South Africa, the courts held that the executive couldn't do this. They had to go to Parliament to get it, and that their effort to withdraw was void. And they haven't come back with another one yet. Burundi, which is under investigation, did successfully withdraw, although they can't withdraw retroactively, so that the cases that are proceeding can still proceed. It's just that after the withdrawal becomes effective, you can't bring any new proceedings in respect of new stuff. So,
okay. My name is
I'm sorry.
My name is
my hearing's an old man.
I'm from Nigeria.
Yeah.
I want to ask, maybe you will explain to us, because while I was in Nigeria working as a journalist, a lot of people used to have arguments with the ICC, and the argument is always, why is it that most of the countries that were indicted by the ICC are
the African countries, you mean?
Apart from Africa, they were all African countries.
Yeah.
Apart from Slobodan and the rest of the other West Africans. So why? And then they make that argument that it is somehow against the African countries. So
I've heard this a lot too. The African countries are all saying, well, you're blaming us, but they're not blaming Asia or South Africa.
I think the initial prosecutor made some mistakes in not pursuing some other cases. But putting that aside, the African bloc has the largest number of states parties to the treaty, well over 30 African states. I mean, they were solid supporters of the court. But another interesting thing happened, in particular from the Democratic Republic of Congo, Cote d'Ivoire, Central African Republic. And I must confess, in my innocent way, it's something I hadn't thought about. And that's this. How do you take a case to the court? Well, a state party can refer it to the prosecutor and say, please do something about this. I always assumed that Samoa would refer a case against Fiji or whatever. Fijians are doing this awful stuff, and so on. But what happened from early on was governments, and of course this goes back in a sense to my terrorism point, governments discovered that they had awful people doing awful things in their state, which they couldn't themselves deal with. So they said, good idea, let's get the ICC to deal with it. And most of those early African cases came in that way. Uganda, for example, the Lord's Resistance Army, Uganda says, get after these guys, and the Congo's got the same problem, and so on. So there was a number of those early cases that in some ways I thought, I think the prosecutor, this is great, and I'll do a few more. And it was a mistake. There were others that he should have done. He did look, for example, at Colombia at one point, and claimed some success in moving the peace negotiations along, but didn't prosecute anybody. And as I say, got to Afghanistan ultimately. But there are plenty of other places. And look, it's a big problem in the law anyway, which is how do you use your resources and what calls do you make when you don't have enough resources. This is a court that can do maybe half a dozen cases a year at most, and there are thousands of cases out there that you could be doing. So you've got to be selective, and that's a very difficult thing to do with prosecutorial resources and so on. And I think the first prosecutor blew that. The current prosecutor is from the Gambia. She, of course, was in an awkward situation when the Gambia was withdrawing that, although she's not there in a Gambian capacity, but she's there because she's a damn good prosecutor. But that worked out. And she's been, I think, much more sensitive to the issue than Marino Ocampo, the Argentinian, who was the first. What's that?
There's only one prosecutor?
Well, that's the chief. And
Right.
Yeah, no, look, you're there's a pretty large bureaucracy. My guess is that, think about a court. There are 18 judges. There's prosecutors, a lot, investigators, and there's the registry, the people who deal with victims. It's a big bureaucracy. My guess is about 800 or 900 people work in the new building in the Hague. It's got up to about that. It's about 120 million euros a year budget. Which is, depends how you look at this. It's peanuts to the people who pay most of the budget. A lot of money. It's more than frankly, it's more than the Samoan regular budget for everything. But in terms of the United States, if it were paying, or Japan, which pays about 20% of the budget, it's peanuts on their budget. But takes a big bureaucracy to run an operation.
So the United States helps pay for it? But
that was a big fight, actually, about whether we would amend the United Nations Charter and make it like the International Court of Justice, which does state against state cases, make it part of the UN. But the United States and others made absolutely clear that wasn't going to happen. So you end up as a separate international organisation on a budget which is essentially based on the same formula as the UN budget, which means the wealthiest people pay most. So the Japanese, in terms of their GDP, they'd probably be in for about 22%, I think, but they maxed it out at 20. The EU, between them, pays at least that, maybe more. The Germans are the second biggest contributors, then the French, British, Italians, around about the same. So, as I say, the Japanese and the European Union pay most of it. The small countries contribute about 10,000 euros each, because they're at the bottom of the scale, and relatively small amount.
So China's
I think
not in
we
it?
almost run out of time. Let me ask one additional question. Did Amnesty International, was that really involved?
They were very much involved, and up until Rome, I don't remember Christopher Hall, who was the legal advisor to Amnesty, very able guy, took over as legal advisor after Nigel Rodley moved into academia. He did very good work. Now, from my point of view, Amnesty was totally deficient and absent, missing in action on the aggression part of the negotiation. And now, you've all been members of Amnesty long enough to understand about the whole mandate arguments and so on. I was a member when Amnesty first got into the capital punishment issue, and my group people bailed because they didn't think we should be doing that, and then some more bailed over the torture issue and so on. I don't know, I've had big arguments with Amnesty over aggression, and earlier over the question of self-determination, for example, in East Timor. They said, the people getting killed will worry about the human rights, but the fundamental problem in East Timor was aggression and denial of self-determination by the Indonesians. But Amnesty just never wanted to stick up its head and do with that. But that's a whole other debate about the mandate. And some of Amnesty's charm is it just deals with a limited range of issues. And I thought it was a great misfortune that they didn't take a much stronger view on aggression. And I think they could have shortened the negotiation and added some expertise that would have been useful. Hey, water under the bridge at this stage. And Chris Hall died in the middle of this, so he's not around to defend himself.
Roger, thank you so much.
It's a pleasure.
We're going to kind of have our